Our next case this morning is 2019-1355, A.J.R. et al. Versus the Board of Education of Toledo City School District et al. For the appellant, Ms. Dawson.
Thank you, Your Honor. Chief Justice O'Connor, members of the Supreme Court, Mr. Glaze. May it please the court. My name is Jennifer Ross. Cynthia Scaff and Ralph Shady. I would like to reserve 3 minutes for rebuttal. The three educators before this court should be held immune from liability pursuant to Revised Code 274403, unless they acted with malicious purpose, in bad faith, or in a wanton or reckless manner. Appellees allege the educators acted recklessly. They did not. This court has held that recklessness, distilled to its essence in the context of the immunity statute, is a, quote, perverse disregard of a known risk, or that, quote, the actor must be conscious that his conduct will, in all probability, result in injury. Even construing the admissible evidence in the record most strongly in appellee's favor, reasonable minds could come to but one conclusion. Appellees fail to establish that any of the educators perversely disregarded a known risk, or that they knew their conduct would, in all probability, result in A.R. being injured. Therefore, the Court of Appeals decision should be reversed. Before going further, I want to clarify that, as in our brief, I will refer to the kindergartner who allegedly was being teased as A.R., and the kindergartner who is alleged to have done the teasing as S. The undisputed facts in the record show that in response to reports of teasing, the educators spoke with the kindergartners about the alleged teasing promptly, regularly monitored the students in the lunchroom and classroom, and frequently checked in with A.R. to ask her how she was doing. A.R. assured the educators that all was well and she was fine. To determine whether any of the educators perversely disregarded a known risk, it is critical to look past appellee's characterizations of the evidence and consider only the admissible evidence in the record before this court. Appellees argue that A.R.'s parents notified the educators 4 times that A.R. was being bullied, and they submitted affidavits regarding their own conversations with their daughter. But the only admissible evidence in the record of specifically what they claim they told the educators before the alleged incident is that the kindergartners teased A.R. for being 4 years old and tried to convince A.R. to drink a mixture of food and milk in the lunchroom. It's essential to sift through appellee's characterizations and generalizations in order to determine specifically what notice each educator had of the teasing before the alleged incident and how each educator responded.
Counsel, wasn't there some allegations that A.R. was jostled or pushed in lines? Was that not evidence?
Your Honor, the only evidence of that is that A.R. told her parents of that, and there was no, but we assume that for the purpose of summary judgment, even though it's not clear that the parents reported that to any of the educators, we're assuming for purposes of summary judgment that they did. But Your Honor, jostling in line, it's very typical of kindergartner behavior, and it's certainly not a harbinger of a violent act to follow. So even assuming that happened, and it is not at all clear that it happened. And by the way, it's not clear that it was, even if the jostling occurred, that it was S who pushed A.R. There's no evidence of that at all. So there's no indication based on that S would later cause any harm to A.R. So considering the record regarding Cynthia Scaff, Assistant Principal Scaff was informed by A.R.'s father in October about his concern that S was teasing A.R. During that discussion, A.R.'s father claimed that A.R. was being teased for being 4, but he did not mention any other specifics. It is uncontroverted that shortly after that conversation, Ms. Scaff spoke to A.R. and S. about the teasing. A.R. told Ms. Scaff that no one was being mean to her and S. was her friend. Now, A.R.'s mother later claimed she discussed a food issue that in the denies A.R.'s report regarding, Ms. Scaff denies that A.R.'s mother claimed that she discussed that. Nevertheless, and assuming that allegation is true, Ms. Scaff's actions showed that she reacted diligently and conscientiously. It's uncontroverted that out of an abundance of caution, Ms. Scaff checked in with A.R. periodically in both the lunchroom and the classroom. So based on Ms. Scaff's personal observation during these periodic checks in the lunchroom and the classroom, A.R.'s assurances to Ms. Scaff that she was fine, and because S. had no history of discipline or violence, Ms. Scaff had no reason to believe that S. would physically harm A.R. There is simply no evidence in this case that Ms. Scaff perversely disregarded a known risk or that she knew her conduct in all probability would result in A.R. being injured.
Counsel, would you, I'd like to direct you to the actual incident. I guess there was no communication with regards to the injury. In fact, the child went to school the next day.
Yes, Your Honor. So first of all, Your Honor, the admissible evidence before this court is that Ms. Lute testified by way of affidavit that although she was right in the room when it allegedly happened, both she and her assistant teacher were in the room when it happened. She saw nothing, she heard nothing, she didn't hear any crying, she didn't hear any screaming, no student reported the incident to her. And so she says she was, if the incident occurred, she was unaware of it. The other admissible evidence in the record is that when A.R.'s mother picked her up from school that day, she noticed a mark, but instead of taking her for treatment at an emergency room, she took her to a Girl Scout meeting. And she also sent her back to school the next day.
Is there a medical report here?
The only medical report is unauthenticated. And again, setting that aside, what the medical report is that 4 days later at a well check, the pediatrician noted that there was a poke. He called it a poke, and he prescribed no treatment whatsoever.
Well, Counselor, is there reasons for this information to say that the injury wasn't severe enough to rise to the level of this claim by A.R. and her parents?
No, Your Honor. What happened after the incident is not relevant to the issue before this case. The issue is recklessness, and the only issue is what the educators knew before the incident and how they responded.
So regardless of the severity or lack thereof of the injury, it's not relevant. Okay.
Yes, Your Honor. Next, consider the record regarding Ralph Shady. In response to a report that some kindergartners were teasing A.R. for being 4, Principal Shady spoke with the other kindergartners and frequently visited A.R. in the lunchroom. It is uncontroverted that during these visits, he found A.R. eating lunch with the kindergartners, who allegedly previously teased her for being 4. A.R. always told Mr. Shady that she was doing well. A.R.'s parents claim they told Mr. Shady that A.R. was being teased in the lunchroom. Although Mr. Shady denies this, assuming for purposes of summary judgment that allegation is true, yet Mr. Shady's periodic visits to the lunchroom and checking with A.R. during these visits was the appropriate response. Because A.R. repeatedly assured Mr. Shady she was fine, and Mr. Shady did not himself observe any teasing during his frequent visits with A.R., and because S. had no history of discipline or violence, Mr. Shady had no reason to believe that S would physically harm AR. There's simply no evidence in this case that Mr. Shady perversely disregarded a known risk or that he knew his conduct in all probability would result in AR being injured. Finally, consider the record regarding Amanda Lute, AR's kindergarten teacher. Ms. Lute was on leave during the first part of the school year, but she was told when she returned in November that other kindergartners had teased AR for being 4. She stated this type of teasing was not unusual in kindergartners, but she nevertheless monitored the situation to ensure there would be no teasing. It is uncontroverted that Ms. Lute never observed any teasing during AR's more than 3 months in the classroom with Ms. Lute and S. S was in the classroom too. Also, Ms. Lute spoke regularly to with AR's mother, who never mentioned concerns to Ms. Lute about AR being teased. And although AR's father claims he told Ms. Lute that he hoped her birthday party would eliminate issues and teasing, there's no evidence in the record that either parent made any specific report to Ms. Lute regarding teasing at all. Because Ms. Lute never observed any teasing in the more than 3 months she was with the students before the incident, and because S had no history of discipline or violence, Ms. Lute had no reason to believe that S would physically harm AR. So there's no evidence in this case that Ms. Lute perversely disregarded a known risk or that she knew her conduct in all probability would result in AR being injured either. It is true that AR's parents allege their daughter told them about name calling such as baby, teasing for being 4 years old, pushing in the bathroom line, and leaving out of a playgroup. But there's no evidence in the record about specifically which of these allegations they communicated to which educator. Nevertheless, even assuming for purposes of summary judgment that AR's parents communicated all of these allegations to all of the educators, none of these alleged statements put the educators on notice that S would physically harm AR. This is especially true because even though AR's parents informed the educators that S and other kindergartners had teased AR, they don't even allege that they reported any instances of physically harming or even threatening to harm AR. Further, it's undisputed that S had no prior discipline in her file, no history of physically harming or threatening to harm anyone, and certainly no history of physically harming or threatening to harm AR. In conclusion, the evidence is that after being informed of teasing, the educators monitored the situation and periodically visited AR to make sure she was doing well. AR gave no indication to the educator she was not doing well. To the contrary, and importantly, AR said that no one was being mean to her and S was her friend. AR's parents' allegations regarding the educator's notice before the incident, even as assumed to be true for the purposes of summary judgment, do not establish that any of the educators perversely disregarded a known risk or that any of them knew that their conduct in all probability would result in AR being injured. We request this court to reverse the appellate court decision and hold that the immunity statute shields these 3 educators from liability because reasonable minds could only conclude that the evidence, even when viewed most favorably to the appellees, failed to establish a genuine issue of a material fact and establishes that the educators did not perversely disregard a known risk and did not know their conduct in all probability would result in AR being injured and therefore were not reckless. I'd like to reserve my remaining time for rebuttal. Thank you.
Thank you. Mr. Glaze?
Chief Justice O'Connor and Justices of the Court, my name is Anthony Glaze and I represent the appellee, A.R. The main issue on appeal today is whether or not A.R. has presented sufficient evidentiary material to satisfy the reciprocal burden to appellant's motion for summary judgment under Ohio Civil Rule 56. More specifically, appellants claim that there are no genuine issues of material facts here, and thus they are immune from civil liability as a political subdivision employee, and are therefore entitled to judgment as a matter of law. However, when construing all evidence and inferences in our favor, in favor of A.R. as the non-moving party, and when viewing appellant's evidence with a skeptical eye, it is clear that A.R. has presented several genuine issues of material facts. Here, the most glaring issue of a material fact is whether appellants witnessed the bullying incident in March when A.R. was stabbed and slashed in the face. But regardless of these disputed facts, appellants claim that they are still immune from civil liability.
So I wonder if I could stop you there. You said the first issue of material fact was whether they witnessed what occurred. So tell me about that. What evidence is there in the record?
That the incident occurred in March?
No, maybe I misheard you. I thought as I was writing down, you said, here are the issues. So I started following you and listing them. And I understood that the very first issue that you identified was whether defendants actually witnessed what occurred. Is that not right? What I'm looking for is really a list of what do you think the remaining issues of material fact are?
Okay, yeah. So, the one question of fact is, whether or not the incident happened, but assuming that it did for purposes of summary judgment, then the next one is whether or not they saw it. And if they did, then why wasn't it addressed? Why wasn't care provided? And why wasn't it reported?
So what
Is there a
evidence-
dispute about that fact? Is there contradictory evidence on that?
Well, yes, in Appellant Lute's affidavit, she testified that she did not see it or witness it or.
Right, but did anyone testify that she did?
Yes, through the A.R.'s parents' affidavits when they reflect their conversations with with A.R., as well as the incident report from the principal when he interviewed us, and she recounted the facts and reported in the report that A.R. reported this incident to the teacher, and the teacher made her apologize.
But that's different from whether she witnessed it. Is there any evidence? Is there a dispute about whether the teacher actually witnessed the incident?
Well, if you consider the facts in the affidavit as well as the principal's report, then yes, there is a question as to whether or not she saw it. But even assuming if she didn't, that brings in our issue of, well, was this reckless supervision? When should she have saw it, and at what point? So moving on, and again, so despite these disputed facts, they are still presumed to be immune from civil liability. So then the issue becomes whether or not A.R. has presented sufficient evidentiary material to rebut appellant's presumption of qualified immunity. The immunity statute provides 3 exceptions, and the only exception addressed by the lower courts was recklessness. More specifically, were the appellant's acts or omissions conducted in a reckless manner. And generally speaking, when determining recklessness as a matter of law, the court will look at specific facts and evidence, and then the question of recklessness will be considered on a case-by-case basis. So here, in this case, there are 2 key factors to consider when analyzing the recklessness exception. One is that at the time of the bullying incidents, A.R. was a very young child and was considered a child of tender years, who was unable to protect and care for herself as a matter of law. And 2, A.R. and the appellants were in a student-teacher relationship, which is recognized as a special relationship under Ohio law. So as a result of these 2 factors, the standard of care is altered and a heightened duty is owed, and the reckless standard needs to be analyzed accordingly. And this is especially true because appellants knew that A.R. was an early entrant, gifted student, and this was her first experience of peer-to-peer interaction.
Counselor, is a heightened duty or heightened standard owed individually to AR or to AR and all the other students, to the class in general?
Yeah, generally speaking, it's owed to all of the children in the class, the children at age 4 and 5 that are considered of tender years and cannot protect themselves.
So what more could have been done here to protect ARS, everyone in the class from, if the allegations are true, conduct of children against each other in this manner?
Well, so, as the 6th district noted, they could have kept the children separate or possibly in a different classroom, and they shouldn't have partnered.
So
AR.
you think one of the students should have been moved to another class?
I think, yes, that's a reasonable step to take.
Which one?
Excuse me, what?
Which one should have been moved?
Well, I don't think that necessarily matters. It could have been either one.
Why wouldn't that matter? Why wouldn't it matter which child you're taking and removing from a class?
Well, I think that just the bigger point is just take reasonable actions to keep the children that have known issues separate and safe, and then ultimately supervise them. So as in, yes, if they didn't move them to a separate classroom, you still don't partner them. If they have known issues, you don't give them sharp objects, and then you don't turn a blind eye. And as far as what they could have done better, that's all part of the recklessness analysis, as well as questions of facts. So,
Counsel, the concern I'm having with your argument is that you speak in terms of reasonableness, and it would have been reasonable. It would have been more reasonable to move one of the children to a different classroom. But is that our standard? I mean, what I think we're looking for is there a perverse disregard for
Sure.
a duty that's owed? And so what, in your view, is perverse about, what is it that's reckless about the actions that they took? Not in terms of reasonableness, but in terms of recklessness.
Sure. Well, again, and that's why the main thing to remember is that we're talking about trained professionals that are responsible for kindergartner students. So when you note that there's a special relationship in a child of tender years, the facts presented on that, again, they weren't kept separate. They were placed alone at the table and required to be partners, required to work together, given sharp objects, and then turned a blind eye when they cannot protect.
Wait a minute, you said turned a blind eye. Is there any evidence in this record that either the teacher or the principal turned a blind eye?
Well, yes, because one testified that they did not see the bullying incident, or any incident for that matter. And again, A.R. said that she told her parents, and that's reflected in the affidavit, that she told her teacher about this incident, as well as the report with the principal. So again,
Counsel, do you know how many students were in the classroom at the time this alleged incident occurred?
Not off the top of my head, I believe it's in the record. I don't really want to guess, but I think it was approximately 20.
Approximately 20
I think
5-year-olds?
I think so, correct.
And there was a teacher and a teacher's aide, correct?
Correct. Okay, so moving on, back to this reckless conduct and the conscious disregard to the known risk. And I want to highlight the known risk in this case. And the known risk is bullying. And that's bullying in all forms, and that's defined by appellant's own policy. And that includes social bullying, emotional, relational, and physical. And generally speaking, bullying in the classroom is a known risk. However, in this specific case, there is evidence that A.R. and her parents notified the teachers and administrators of A.R. being bullied by the same classmate, known as S, on at least 4 occasions. And the record reflects that the teachers and administrators were either aware or should have been aware of S bullying A.R. socially, emotionally, verbally, and physically throughout the school year. So moving on to the conscious disregard, again, when remembering that we're talking about kindergarten students and the special relationship of the teacher, and as highlighted by the appellate court, it was unreasonable and potentially a question of fact to whether or not it was reckless to not keep them separate, partner, give them sharp objects, and then fail to supervise. And then additionally, if you look at the totality of the circumstances, how really there was no bullying prevention or planning done from the beginning of the school year throughout. And if you consider that, those are the aggravating factors that increase this beyond mere negligence, because again, we're talking about the actions and inactions of professionals related to kindergartners. And even more troubling that after the stab and slash, the teachers and administrators failed to provide any attention or care to A.R. and failed to report the incident to A.R.'s parents.
Counsel, you used the word stab and slash. Can you describe what happened?
Yes, so again, that's also captured in the parents' affidavits as A.R. reported it to them. And it was essentially that the bully came over with a sharp pencil and went like this and hit her in the cheek, and then did it again and caused a slash mark. And if you look at the picture attached to in the record and attached to our brief, which was taken, I believe, 4 days after the incident, there is a noticeable puncture wound that doesn't happen with just a general poke. You need actual force to create what's in that picture. And that's why we refer to it as a stab and slash, and that's also was recognized by the appellate court.
Counselor, what evidence there would then in the record noting the severity that you've described of this injury? What evidence that was there in the record that the educators knew or should have known or should have had some reason to know, or reckless in not knowing, that this child S could and would exact that kind of injury on A.R. or any other child?
Sure. So, there's evidence related to the past physical bullying, and that was being pushed.
But anything rising to this level of injury?
Well, I mean, just physical bullying in general, yes. So obviously the stabbing is more severe, but it's still considered physical bullying, the same as being pushed in the bathroom line and being forced to eat a nasty concoction of food in the lunchroom. And again, the point is that this increased and escalated over time, and nothing was ever done to address it or prevent it. So what they claim started out as mere teasing escalated to being pushed in line, being bullied in the lunchroom, left out of groups, to here it is a few months later. Now there's another physical bullying incident that was very severe. So the 6th District Court of Appeals found sufficient evidence of recklessness to overcome appellant's presumption of immunity. This alone shows that reasonable minds can find that A.R. presented genuine issues of fact regarding appellant's reckless actions and inactions. And when considering the Ohio Civil Rule 56 standard, A.R. has presented sufficient evidentiary material, and the questions of fact presented in this specific case are best suited for the finder of fact. And here there are questions of fact as to the mindset and credibility of appellant's actions and inactions as to whether or not they consciously disregarded known bullying. A.R. experienced different forms of bullying that increased and escalated during the first 6 months of her kindergarten year, and appellants did nothing to address it or prevent it. This case is about holding the public educators responsible and accountable for severely disregarding.
You say they did nothing. I believe that we heard testimony that the principal as well as the teachers checked in with A.R. frequently to see how she was doing. And the other students were the concept of or the practice of bullying was addressed with them. So do you deny that that happened?
Well, I think number one, it is a question of fact of whether or not it happened. And
Well, I'm just asking, is there contrary evidence?
well, yeah, so obviously there's a credibility determination with the appellant's affidavits and whether or not a jury would believe them in this case. And then as well as, again, we're talking about the known bullying at the kindergarten level and the fact that they monitored the situation or checked in with them. Well, one, whether or not that happened, it's clear that they never witnessed any bullying. So that's potential evidence to infer that they did not check in with them, as well as if you notice, they only did their generic wellness checks in passing with A.R. while in the lunchroom or the hallway. They never sat her down alone and talked to her and questioned her and checked on her on her progress. So
would that have been, do you have, I mean, you're saying in your opinion, that's what they should have done? Or do you have expert testimony from some kind of child psychologist that would say, that's how you deal with this?
no, so it's not in my opinion, but it's just a reasonable mind could find that this was minimal at best. And the evidence presented should, especially with A.R.'s own testimony, when she was surrounded by her peers, should only be taken at face value. And there should be more weight given to what A.R. told her parents while alone in a secure private setting.
Thank you.
You.
Your time is up.
Thank you.
Ms. Dawson, you have a minute remaining.
Thank you, Your Honor. This court has held that the manifest statutory purpose of Revised Code Chapter 2744 is the preservation of the fiscal integrity of political subdivisions. If the appellate court's decision denying summary judgment in this case is allowed to stand, school districts across the state employing even the most conscientious educators carrying out their duties with watchful diligence and if educators are exposed to liability every time they are made aware of teasing before an altercation occurs, even when they respond diligently and appropriately, it will discourage educators from remaining in the profession and reduce the number of those willing to enter the profession. A decision that the facts before this court create a genuine issue of material fact as to whether the educators perversely disregarded a known risk or knew their conduct in all probability would result in A.R. being injured would have grave consequences, and it would eviscerate Ohio's statutory immunity. The educators offered sufficient and undisputed evidence to establish that they responded reasonably and responsibly to the information they have.
Thank you.
Thank
Thank you, counsel. We will take the matter under advisement and you'll be notified of our decision.
you.